board and town office employees. They have spread unsubstantiated rumors, misinformation, outright lies, and attempted to interfere with and damage personal relationships and jobs. And after doing these things, they have the audacity to complain that they have received negative feedback from other citizens in Clifton. Since the year 2000, one family has been instrumental in diverting over $1.5 million in tax revenue away from the town of Clifton. The town of Eddington has realized over $825,000 since 2000 from Maine Maritime gas pipeline that passes through Eddington. Not to mention the money paid to landowners for easements where the pipeline passes through their property. This pipeline should have passed through Clifton. In addition, our town has lost $600,000 over the last 2 years in tax revenue that it would have been paid if the current Pisgah project had been permitted. Add another $80,000 in direct tax relief, and you can see the tremendous amount of money this small town has lost over the last 13 years. And I just remembered also, not to mention the over $20,000 in legal fees that the town has had to have utilized to defend itself. And contrary to what Peter Beckford said at the annual town meeting, that he didn't understand why the town was employing an attorney, and all we were doing was supplying an attorney for Pisgah Mountain, you look at the lawsuit, or the filing, and in fact it was put against the town of Clifton and Pisgah Mountain, so the town did have to retain its own attorney. Finally, I wish more citizens could attend these meetings. All I know is you people who want us to be, this board to be very, very transparent. We talk about it and talk about it. However, your own meetings, you have not allowed citizens, certain citizens in this town to go to your meetings, which are very secretive. What scares me is having two people basically here at all the workshops, I'm assuming disseminating the information gathered and bringing it back to the rest of the task force and the other citizens. I'm scared about that because we've had people run into regular citizens out on the street and just get bad information. I didn't know that, I was told this. The most recent one that we have heard is, the latest is the project would cost the town money. This is what we hear, this is what's getting out there. It's like someone refusing a raise in their paycheck because they don't want to pay the taxes on it. Can you imagine that? I mean, I still, to this day and age, even in my job, I talk to people, I have sales reps that will tell me, boy, I'm not going to get any of that money, it's all going to be taken up in taxes, I'm not going to get any of it. So this is the latest that we've heard. We've had to straighten out one citizen and get him on board with that. So I wish there were more people here. I just wish, and I don't understand. I mean, they're obviously, I understand the fear. I understand it's genuine. But I just want to know if it's with being supplied by correct information. They're not here. Their minds are made up. And it's because I'm convinced, anyway, and this is I'm not reflecting anything the other planning board. I'm off the planning board. I wrote this on my own. I'm concerned that their fears are grounded in bad information that's not right. And I'm also convinced that it has really nothing to do with safety. It's to create it, if any of the suggestions or any of what you wanted the planning board to do were implemented into the ordinance, the effect would be denying any large wind energy facility of incorporating or coming in under, being permitted in this town. That's the effect. I believe in my heart that's the goal. And it's been so frustrating because that's why I call it the dance. We dance around. Eric mentioned that the task force on wind has made the ordinance tougher. And that's right, they've pushed and pushed and pushed the task force on wind to the point where, you know what, I mean, the goal is to just ordinance out. That's all I have to say.
Thank you.
Do you want to typewrite those, or?
Well, you'll have to redo it because I got notes that I
So
took.
you can typewrite it and send it to Debbie tomorrow, would be good. Paula, go ahead.
I find it really
Excuse me.
kind of surreal, I guess, to hear. We don't have no secret handshakes. walk down the street, is that a member or not? They're not, I'm not. I don't pay no dues to anybody, I don't belong to an organization. I don't know how people are identified as task force people. We don't have, it's not a membership organization. That has been explained to the board before.
But Paula, you are registered.
It's registered as, I forget what the name of it is. It's like it's an associate, mutual benefit association.
Yeah, that's right, exactly. Yeah, Julie explained that a couple years ago, mutual benefit
It's a mutual
association.
benefit association. There's no membership list, there's no.
Did you not deny a citizen of this
There's no
town?
meetings that.
But did you not deny a citizen of this town to attend one of your meetings?
We don't have like meetings. You know,
I'm just
if
kidding.
anyone's interested in being on my email list, I'll take their email and send them anything that I have.
In other words, what you're trying to say, you've never had a meeting.
Well, what do you call a meeting?
Well, that's not really, at this point, just one of the, I will actually clarify something now, because it's not really any of our business for like what a group of private citizens want to do. However, I will say, you know, when I was going through all this, one of the things that we had a problem with initially was, and I felt bad about it, and because I hadn't really thought about it going into it, was there were kind of like two different like groups initially that were kind of getting involved, and they kind of coalesced into this Clifton Task Force on wind. And they wanted to have like an interested party status. And I remember having this big discussion about that. We had not even, you know, procedurally, Paul, we didn't even think about that when we were writing it. That wasn't really, we were just thinking about adjoiners. And so coming up to this, I remembered how difficult that was just to get through that part of this whole process. And so what is in the new ordinance is the idea of having these interveners, you know, being able to register and having disclosure about what they are, and it's kind of geared for the big projects. I don't think I required that sort of a thing going on for the smaller projects, because I just didn't see that that would be predominantly like small subdivisions and things like that would just be adjoiner sort of issues. And we didn't need to elevate this, but there is that whole section about interveners in there that really makes it rock solid as to who they are and stuff like that, which makes it everybody on an even playing field and gives opportunity for direct input. And even in the process, you know, once you're registered as an intervener, and I got it from Vermont through their environmental review process. So the way it would work roughly would be, so the applicant comes in and provides information, the intervener has time to respond to that information. Then we come to a point, we actually have in the new procedures, we move to stop for taking new information. Okay, so there's an actual, you know, gate, and it's voted on, and it's done. So then the planning board is in the middle of deliberating. Well, then the planning board discovers that it doesn't have all of the information it needs to make a decision. The planning board has to vote to go outside the gate again. Okay, applicant, provide information. Well, then we don't just close the gate with the applicant's information. The whole process is set up and designed to have the intervener provide input, you know, in response to the applicant. Okay, so it's not, you know, then you close, the planning board has to go back, close the gate, and go back into it, because part of the problem for how we ended up where we got to, you know, regarding some of the evidentiary issues that were in the court trial were the judge reviewed evidence that the planning board never reviewed, and then we weren't allowed to have, and then the planning, in terms of that factor, all we ever looked at was the first review of it, and then the second review of the factor, with the factor going from 0.5 to 0. We never got to look at the information with the factor at 1, but the judge did. And the judge said we couldn't have our consultant talk to us about what that actually meant. So, you know, that was a bad situation. And you know, and I think if the judge looked over the ordinance, I mean, it was kind of sort of in there for how that worked, but not very good about how that all worked in the ordinance. The new ordinance, you know, makes it very clear as to when stuff starts and stops. So, you know, that would, you know, if you're looking at ways to avoid litigation, I think, Andy, you would agree that that would be a way to avoid litigation by having clear gates. Is that accurate?
I think that's one potential. I haven't looked at the specific procedure that you're setting up. The only thing I would note is it can be helpful, but the concern I would have, just from a general comment from a legal perspective, is when you're dealing with an applicant, any type of applicant, they're going to have a property interest at stake, which means they have constitutionally protected due process rights. If you start to elevate or confer certain procedural status for interveners or other individuals, I think you need to be careful, because that shouldn't translate into defining what their rights or interests are at stake in whatever proceeding that is. You could have an intervener from an entirely different community show up who would have very different rights than someone who is in a butter to a project.
Well, we have to show the type of rights, but like if you do look at a larger project, I do think, as I kind of looking back on it, when we were reviewing this project, I believe we actually sent out invitations to the adjoining town offices, and I don't think an official from a town office showed up, but individuals who were members who resided in other towns did show up. But the intent was to allow other municipal officials at their will to show up, and the Vermont process actually engages state agencies as automatically becoming interveners, which that's a legitimate interest for a project where the state's going to be reviewing.
Yeah, I actually went to law school in Vermont, so I'm a little familiar with what they do over there. It doesn't mean it's the correct way of doing it, but the only caution I would throw out there is there, for municipal proceedings, there are state statutes that grant automatic party status to certain officials. And what I would suggest is you should be careful in conferring the same type of status through a local ordinance, which may or may not run afoul of the statutory scheme, is what I'm saying.
I think I did research the issue of parties, and the state of Maine is filled with vagary over parties.
Well, there's a classic example, and not to belabor it, but there's a case where the Department of Environmental Protection did not participate in a local process, and they disagreed with the local decision, and then they challenged that in the judicial court system we have in Maine, and it was held they do not have automatic party status. Even the Attorney General of the state of Maine does not have such status for those types of proceedings.
Well, I'll go back through and take a peek at it. Maybe if you'll be nice to us, you could relay that.
Like, I think, my only
Jess, I see your hand. I'll call you. Thanks, Jess.
I think it'd be helpful to have a very clear process, no matter what that is, when you have proceedings. But I think the typical process is the applicant who has the property rights at stake, which are constitutionally protected, is always given the opportunity to present, whether there's a public hearing or not, or public comment at a public meeting. They're two separate things. Is often depends on the nature of the proceeding and the board's discretion, but usually there's a comment section, and it's for anyone, whether they're a quote-unquote intervener, a butter, or whomever, and then there's an opportunity to respond to rebut and then deliberations and a decision. That's the typical process.
Right.
But a clear process is helpful.
That's what I was trying to do, is clear that up. Go ahead, Jess.
I would just like to be on the record that I was deeply offended by Bill Rand's letter, and being called "you people" is very offensive, and it has been said over and over again.
I mean, probably could have been worded a little bit better, but I think...
I don't understand how anybody could not call that a personal attack.
Well, just to kind of, I don't want to, because I think it's been a really good meeting. There was a bunch of stuff that was dealt with last night, so probably, honestly, like some parts of that letter, like in listening to it, from this side of the table, would probably have been more appropriately taken care of last night at the select board meeting. and Carol did a good job of taking care of a couple issues that came up, regarding that. And there was, in fairness to Bill also, there were some written comments made by various people, that were personal in nature. Again, probably the more appropriate forum for some of those things that he said would have probably been yesterday in that environment as opposed to in the context of reviewing the LUO. So, I mean, I know how you feel. I appreciate how you feel. I know, this is a hard issue for a lot of people. But I just like to say I do appreciate. I thought you had some good questions tonight. I thought that the meeting tonight was good and it was pretty civil. And I'm hoping that we can next week answer some of these questions reasonably. I'll get them posted later this evening for people to go and look at, and that we can kind of go forward in some positive stuff. And I do appreciate that you and Paula have been here every week. I don't think that you were. I think you got every meeting. I think Paula's the only one that of the two of you that missed one. I think the reason she missed one, she was on the phone all night. It was her birthday or something. I think she told me it was good to take her birthday off.
If I may, Eric, I apologize for my comments. When you're speaking ad-libbing, it certainly wasn't in my written comments, so I apologize. A lot of times I find myself picking up nuances of other people, and the person that comes to mind that uses that terminology all the time is Paula, when she stands up here and looks at the board and goes, you people need to realize that you've got to put this, that, and that. And it's used all the time by Paula. You can almost picture her standing up there and saying to the board, you people, and you people. It certainly wasn't meant derogatory, okay? I mean, I can't, even right now, I can't think of another way to, I called you the task force on wind, and Paula says there is no task force on wind.
I didn't say that.
I
I
never said
said,
that.
Yeah,
you can't look at a group of people and say, you're in it and you're not.
okay.
That's not that clear cut.
I have one comment to say on that, because back during when we were talking about making task force on wind an intervener, I know I championed the effort on the board's part to allow you to be interveners. But if I had heard then what you just said, that there was no membership in that organization,
Well,
I would have voted against it.
It's not quite like that. No, I went after they did it. I do remember I went and read about it, and it's a kind of a unique thing in Maine. It's not that big of a deal, but it doesn't require all of the disclosures that a regular corporation has. It's a perfectly legit thing
Not all
to do.
the disclosures, but we're talking about, she just said there are no members. Well, if there's no members, there's no organization.
It's not, either you're a member or you're not.
Right.
Yeah.
It's the organization.
It's a main thing.
The association speaks for people who might not want to speak for themselves, and
Yeah. Just go research it. It's worded oddly.
Kind of like village corporations.
Yeah. So anyway, like I said, it's like 8:35 now, or it's actually 8:30 because I found out yesterday that thing's at least 5 minutes fast.
Eric, just one last comment. Please, everyone, look at this Beaver Ridge sound study. It's very, very important because this is, I don't want to say it's a smoking gun, but it has sound levels in here that are, these are firm levels, a project that's already up and been running for 4 years, I think now. So I would encourage everyone to look at it because it's I don't want to say surprising because this is what we were told all along. I mean, at 3,200 feet, you're at 29 dBA. You can extrapolate that into 4,000 feet, and it's going to be less than that. So, it's a great read.
Does anybody else have anything to say?
I apologize if I call you people. I usually think you guys is what I mean.
Well, you know what, Paul? Everybody has their own things that are sensitive to them. That doesn't bother me at all. Obviously, Jessica might have had different context with growing up or whatever with that, and it might not be good. And I appreciate that. A lot of people have different things that just trigger them, and that's just the way it is for all of us. And I hope that, I think Paul, that Bill is sincere in his apology to you. I don't think he meant to be derogatory, but I can definitely tell that it wasn't a good thing for you. So I'm sorry that you were that way.
Well, his opinions were quite a few lies.
They're just
They're
that
his
opinions. Opinions.
I agree.
Of his
And I
opinions.
can't dispute his opinion,
Right,
but
right.
that's why I'm deeply offended.
So, all right, well, just so you know, I do appreciate what you said. I thought your questions were really good tonight. I did appreciate the questions last week. They made me think about stuff. You know, obviously the one I didn't understand the question. I understand the question better now that Paul rephrased it again tonight and talked about it. So we'll try to re-answer that one question that you answered last week that we didn't kind of get to what you were driving at. So we'll take care of that too. You know what I'm talking about, right? All right. It just didn't nod your head, so I wasn't positive. So, anything else? All right, we're done tonight. We're adjourned. Bruce seconded it.
Again, let me say this straight to you. I'm sorry. I'm awful sorry. I'm sorry you took it that way. I didn't mean it derogatory. I did mention, I understand, I truly believe that the fears that you people have are genuine in your questions you're putting forth.
No, it's okay. I'm fine. How are you?
Would you like this?
Thank you. I have that. Thank you for your apology.
I mean it. I don't like being that way. So.